Right, well, when Lionel asked me a couple of weeks ago whether I'd be able to give this presentation, I rather jumped at the opportunity. It seemed an unparalleled one to give voice to my experiences and views on the interpretation of patent claims. And then I thought again. Addressing an audience as learned as this is always a challenge. Almost anything I say is likely to give rise to debate, so I've decided there's no point in being circumspect. I'll simply say what I think, and if you disagree, shout out. Now, in the course of my practice, I've had to address the meaning of many different types and qualities of patent claims. As Lord Hoffman has pointed out, most claims don't give rise to great difficulty. Their scope is clear, and potential infringers know what they may or may not do. But there are always going to be cases where the boundary of the claim gives rise to difficulty. Every claim written by a patentee is an attempt to delimit something new. If it is a new principle of working, then finding the words to describe it sufficiently accurately to satisfy both the patentee and third parties is fraught with difficulty. Even claims to developments in an established field can give rise to problems. The first person to solve a problem is unlikely in the extreme to devise all the possible solutions. The skill of a patent attorney, and it is a very considerable one, is to see beyond the invention as presented by the inventor and formulate a description which is both certain enough to make clear the limits of what is claimed, whilst being of a sufficient breadth to encompass ways of carrying out the invention which the inventor may not have fully realised, without, of course, making the claim insufficient. It's a task which patent attorneys carry out with considerable creativity and expertise, and those of us who spend our lives dissecting in litigation what they have done would do well to remember just how difficult a task it is. For the purposes of this presentation, I've looked back at cases decided over the past 2 centuries, and it is apparent that the problem with scope of claim is as old as patents themselves. It is also, in my view, apparent that the problem will never go away. There is no magic mantra or formula for construing claims which will allow us to say with certainty in every case what a claim covers, ensuring simultaneously both that the patentee's contribution to technical knowledge is fully protected, and that third parties can be sure where the boundaries of the patented territory, prohibited territory lie. Now, we all know, I'm just going to put these up on the screen because everybody likes slides. Article 69(1) tells us that the scope of the protection is determined by the claims, that the description and drawing should be used to interpret them, and we all know that the protocol tells us that's what we've got to do. And Article 69 tells us that we are to interpret the claims as defining a position between the two extremes, the literal construction and the claims simply serving as a guideline, which combines a fair protection for the patent proprietor with a reasonable degree of legal certainty for third parties. Terrific. And they've just made it all a bit more difficult by adding that. And I don't know what it means, and I'm not sure anybody else knows what it means, because we don't have a doctrine of equivalence, at least I don't think we do, and yet we've got to take into account equivalence of things specified in the claims. And what I've found interesting is that despite this, and despite all the efforts over the last 200 years, that the difficulties with the scope of claim have in reality not changed at all over the course of legal history. All that has changed is the way that the courts describe them, nor in my view has the outcome of individual cases likely to have changed. Looking at the cases, I've formed a clear view that whichever of the techniques for determining the borders of the claim, which I'm going to review in the course of the presentation, had been applied to particular cases, the outcomes would very likely have been the same. Fundamentally, in my view, that is because the borderline cases give rise to an insoluble problem. People considering the facts of those cases can reasonably come to conflicting views. That's why cases like Rhodium, Nienberg and Scholl, which I'm going to use as a paradigm for the problem in a few minutes, as well as an approach taken in a particular part of the last century. What happened was the judges hearing it expressed split views, both in the Court of Appeal, 2-1, and the House of Lords, 3-2. The individual judges simply took a different view of the facts, and in cases like that, that is always going to happen. That is why, in my view, the injunction we find in the last sentence of paragraph 1 of the protocol to Article 69 is simply a pious hope. In the borderline cases, you have to take a view as a judge on where the boundary is to be drawn. There's no point in pretending, as the protocol does, that there is a single right answer. There is only what the particular judge on the particular day, persuaded more or less effectively by the particular advocates for one side or the other, thinks. So, starting 200 odd years ago, in about 1817, we had Thompson and Foreman and Hill. This was a case about iron smelting, unsurprisingly, given the time. The specification set out the materials to be used and the steps to be taken in considerable detail. It's important to appreciate that the patent didn't purport to identify new materials to be used, but simply to describe what was to be said to be a new way of processing those materials. It's also important to appreciate that, of course, in those days there were no claims, so what the court was trying to do was extract from the specification the proper scope of the invention. The evidence of infringement came from a single individual, from the defendant, Mr. Foreman, the son of the defendant and the superintendent of the defendant's works. He said that since seeing the patent, the defendants had preserved cinders which they did not do before, produced pig iron by mixing them with mine rubbish, and that in subsequent processes they applied quicklime to prevent the iron from coming what was called pelled short, which, after reading through the case several times, I think means brittle. But he said that the defendants used different proportions of materials from those specified in the patent. Lime as a 120th part to the total pig iron, rather than the 40th to 60th specified in the patent. And the defendants had used slags in the puddling furnace from before the patent. He also said that the proportions of mine rubbish laid down in the patent were not essential. Mr. Justice Dallas left the question of infringement to the jury, who returned the verdict for the plaintiff. And in the Trinity term the following year, there was a motion to set aside the verdict as being against the evidence. And Dallas J. said this: so what he was looking for was in proportions essentially different from those specified, and yet producing a result similarly beneficial to the result obtained by the court, will not constitute an infringement of the patent. You might think that was clear and straightforward. Either you follow the teaching of the specification or you don't infringe, even if you attain the same or better outcome. But he then went on to say that a slight departure from the specification for the purpose of evasion only would of course be fraud upon the patent, and therefore the question will be whether the mode of working by the defendant has or has not been essentially or substantially different. The court, in the result, accepted Mr. Foreman's evidence that the defendant's process was essentially or substantially different from that set out in the patent, and found that infringement had not been proved. Consequently, the court non-suited the plaintiff and set aside the verdict. About 20 years later, we find Baron Alderson putting it in these terms: mechanical equivalence. The question would be simply whether the defendant's machine was only colourably different, that is, whether it differed merely in the substitution of what are called mechanical equivalents for the contrivance which are resorted to by the patentee. That was a device, an early device for turning piston motion into rotary motion, and the shape of the arms used was different, but that was held to constant matter. A little later, we find colourable difference coming in again in Martin Keating's patents and the Chief Justice Sir Thomas Wilde. Now, this was a patent for wooden paling in which the grain was vertical. And it's quite interesting because this may have a resonance with a case rather later, which we will come to shortly. The two modes of paling have been substantially the same, but a slight inclination can be given to the grain by the defendant, either in order to make a colourable difference or for any other purpose. It would have been an invasion of the patent, but we think the evidence does not show such a substantial identity, but a substantial difference. So we see, first of all, in my view, the court applying exactly the same approach as in Catnip, and secondly, moving away from simply catching colourable differences, that is, those put in simply to avoid infringement, and saying that those put in even for a difference of small enough, a different purpose, even a small enough, would not take the activity outside the scope of the patent. The same year, a little earlier, Lord Cotton and Lord Chancellor had to consider whether a patent for making cement was infringed by using borax in place of an acid as an alkali mixed with gypsum. Borax is, of course, sodium borate, a salt of boric acid. It is therefore the result of mixing an acid with an alkali. And Lord Cotton said what is up on the screen after setting out how the defendant's process worked. I won't bother to read it out to you, you can all read it yourselves. You see, what he was saying at the end is, I claim my invention to be the uniting of gypsum with the acid and the alkali found in borax. It is hardly a different mode of describing the same thing. He has adopted different language, but the language conveys the same meaning. It is the same thing. As a codicil to this one, the patent was subsequently held to be invalid on the ground that it claimed too widely. So only one acid and alkali were actually described, potash and sulfuric acid. The specification said others could be used. None of the ones the patentee had tried had worked as well as those two. That was all it said. The court held that claiming all acids and alkalis was too broad a claim. It either included combinations which would not work, what we would call inutility, which I now suppose we have to call insufficiency, or which was a claim to all which do work and was bad because it didn't say which did and which did not work, so as to eliminate the need for the public to perform experiments to find out the other version of insufficiency that we now have. But as I said, nothing much changes. By 1908, so a little over half a century later, we come to this, and this I've picked out because this is a quote that is referenced 60 years later in Thomas Blanco Whic's absolutely superb final version of Patents for Inventions under the old law, as still representing the law. And what Lord Lorreburn said is, and again, this is still the case, there are no special canons of construction applicable to specifications, nor am I able to accept, if indeed I rightly understand them, certain formidable generalizations presented to us in argument as to the principles to which they've been interpreted. The rest of the specification may be considered, in other words, the context, in order to assist in comprehending and construing the claim, but the claim must state, either by express words or by plain reference, what is the invention for which protection is demanded. The idea of allowing a patentee to use perfectly general language in the claim and subsequently to restrict or expand or qualify, as therein expressed by borrowing the gloss from other parts of the specification, is wholly inadmissible. So wholly original. And then, this is what he described the argument being put to him as. We are asked to construe the claim with reference to the specification, not in order to understand what the former says, but to make it say things which it in fact does not say at all. I thought that was a wonderful quote. And here we find certainty in the second paragraph I put up on the screen. So the courts are they're addressing exactly the same difficulty. They're struggling, trying to work out how you manage both to provide fair protection for the patentee and reasonable certainty. Now, by the middle of the last century, the 20th century, the courts have developed the principle to claim covered things which differed only in essential features. If what was called the pith and marrow of the invention was taken, then there was infringement. And with Vanderlei and Bamford's, the Hayward case, which is very famous, is often cited, Lord Reed, as pith and marrow. But as you'll see from that quotation, the term pith and marrow was in fact a matter of some antiquity, having originated in 1877, of course before the claims. But it remained throughout its life a matter of contention. The arguments in later cases, I discover, record Lionel Hill repeatedly, but unsuccessfully arguing for the House of Lords, that the speeches of the House of Lords in EMI and Listen in 1923 had laid the doctrine of pith and marrow to rest, but it was still alive and kicking in the 60s and 70s. The reason, of course, why the doctrine refused to die was that it was was that too strict a compliance with the language of the claim, the strict literal language of the claim, would in hard cases refuse relief to a meritorious patentee whose only fault was to have framed his claim in language which the judges considered could not be read onto the alleged infringement. So those same judges looked for ways to ameliorate the problem by allowing claims to stretch a little where the features did not seem to them to matter. Of course, this immediately leads to uncertainty, at least until the courts are pronounced, as to the true scope of the claim. And it also leads to difficulty in any form of prediction, because you don't know what the individual judges' predilections will be. Now, the example, I think the perfect example of this problem, is this case. This was a watch strap. There's the claim, but let me show you a picture first. It was an expanding watch strap made up of links which were formed of closed or open-ended tubes with, you can see, U-shaped links pushed into them and held in place by the springs. What happens when you pull it apart is that the springs, by torsion, twist and allow the links to move diagonally in relation to each other. And there are two layers of links, so they move over each other, and the watch strap opens up. These things were very popular in the 60s. And it was claimed in this way: an extendable chain band, more particularly a wristwatch bracelet made of hollow links and connecting links, which connect the hollow links in an articulated manner so it can be pulled apart, pivot against spring action, characterised by this. There were no characterising rules in claims in those days, but we see it in there. It was a claim of German origin, which may have something to do with it. The hollow links are constituted by two layers of cylindrical sleeves of any desired section, which are arranged transversely to and relatively staggered, the longitudinal direction of the chain band, so they're over each other and staggered. And the connecting links are constituted by U-shaped connecting bows. That's the critical phrase in the claim, which gave rise to all the argument. Arranged in the longitudinal edges of the chain, which bows are inserted in pairs with one of the limbs of each of the open ends, the sleeve, one layer, the other limb in one of the adjacent sleeves, so you've got a limb up and a limb down, and in a staggered position. So it's a leaf spring comprising a bent spring plate that's provided in each sleeve. The spring plate keeps the connecting bows firm in the sleeve and acts by spring action against their pivoting, and the chain is stretched or bent. Now notice that the spring action is not defined as being any particular form of spring action. In fact, it's torsion in that one. And so that's the cross-section through the band as patented. Now that's the first infringement. Scholl's first infringement called Excalibur 59. And put simply, the only difference between this and the claim is that the two U-shapes which link the links of the watch band have been joined along one edge into what was described throughout the case as a C shape. There's still springs in there to provide the spring force, and mechanically, as far as I can see, although some of the judges clearly just didn't think this was right, mechanically there is essentially no difference between the assembled units. Obviously you can't put them together the same way because you can't push the C in from the ends. And there was argument, we go back to the claim, there was argument about which bows are inserted in pairs, whether inserted meant that you had to be able to insert them into the links of the watch band, or whether it just meant that that's where they were when they finally arrived. Everybody finally agreed that it just meant that that's where they were located. And then Scholl came up with an even slightly cleverer one, in which the two links were now not only combined into one, but the spring in the top half was incorporated into the seat. So that top curve is a seat. Now, as you can imagine, that gave rise to quite a lot of debate at every level. And what's fascinating is at each level the judges just couldn't agree. In the Court of Appeal, they decided 2-1 that neither of those infringed. And finally, in the House of Lords, they decided 3-2 that neither infringed, but the two dissenters decided that that one did, but the one in which the spring was incorporated into the link didn't. Now, if you're going to go that far, what's the problem with going that far? I can't even understand it. It's worth reading, but it is incomprehensible. So that's where we were in the late 60s, early 70s. And if you read the green version of Blanco White's book, which was published, I think, in 1973, you will see that law set out in a couple of very simple paragraphs, which are a paradigm of good legal writing. The strict linguistic approach to construction of documents has caused difficulty in all spheres of legal interpretation. Contracts were just as prone to require understanding through the eyes of a reasonable businessman as patents were through the eyes of persons skilled in the art. And as a result, there was a gradual sea change to the court's attitude to interpretation in the 1970s. And a different approach began to be adopted. And you all know what it is. A document was looked at one as trying to convey a meaning to the reader, and it was that meaning which was the object of construing the document to extract. So you looked at it through the eyes of the reader to whom it's addressed. Looking at the meaning of documents in this way was called purposive construction, as Lord Diplock explained in Capnick, and this was supposed to be the cure for the problems that had existed heretofore. The intention was to attribute to the words of the claim the meaning which a person with a practical interest in putting the invention into effect would take from them. I've highlighted in that quotation the key sentence. It was a notable change from the approach previously adopted by the courts and set out in the contemporary textbooks, in which it was the meaning of the words and not how they would be understood by the skilled reader which ruled in construction. And that it was, of course, that which had given rise to the need to develop the concept of essential and inessential features, the idea of thick and narrow, in order to get round the fact that the meaning of the claim, as so interpreted, wouldn't give effect to what everybody expected. We can actually see that even in relation to patents, the philosophy was beginning to change as early as the decision in Radio Meaning Program. At first instance, Mr. Justice Whitford in Capnick cited a passage from Lord Whic, who was one of the minority, where he said this: "No doubt if the reader of a specification is astute enough to see that the patentee has framed his claim so narrowly as to leave it open to him by some small modification to use the invention without infringing the claim, he is quite entitled to do that. He cannot be accused of sharp practice. He is within his legal rights. But claims are not addressed to conveyancers, they are addressed to practical men skilled in the prior art. And I do not think they ought to be construed with that meticulousness, which was once thought appropriate for conveyancing documents." So we can see that it was the passage of time that gradually led the minority view to become a majority. And Lord Diplock framed the question to be asked at the end of the passage I've quoted. The question in each case is whether the person's practical knowledge and experience of the kind of work for which the invention is intended to be used would understand strict compliance with a particular descriptive word or phrase appearing in the claim is intended by the patentee to be an essential requirement of the invention, so that any variant will fall outside the monopoly claim even though it's done in a material way, from the way in which the invention worked. And he went on to say that the question didn't arise where the variant would have a material effect, and that it was to be answered in the negative only where it was obvious at the date of the specification that the variant would have no effect. Otherwise, the reader was entitled to assume that the patentee meant what he said in the claim, and anything not to comply with its words was outside it. It was by applying this approach that the House of Lords concluded that a builder to whom the specification in that case was addressed would not regard the word vertical as being strictly vertical, but anything sufficiently close to provide the necessary strength for the lintel. Of course, the claim was not addressed to a builder at all, in reality, but to a structural engineer. But we have to assume this was really the kind of person that all did not every month. Lord Hoffman uncompressed, Mr. Justice Hoffman, as he then was, uncompressed the Catnick decision in Improver and turned out the protocol questions. And by 2005, the Improver questions had become treated almost as statutory rules. It became increasingly clear this didn't always work. And in 2005, Lord Hoffman delivered what, in my view, is the finest ever speech on construction of claims. All I can say to you is you have to go and read it. It's an absolute masterwork, and it will tell you everything you need to know about how to approach claims. Our chairman today described it as magisterial in activists and Eli Lilly, which I think is very fair, and continuing to uphold post-study. I wholeheartedly agree. What he concludes is that in substance, the Improver or protocol questions, whilst useful guidance in some cases, are often redundant. Frequently the question is resolved by determining what the real invention is. Once one has done that, as he put it, the protocol questions answer themselves. And Kirin Amgen was a very good example of that on the facts. And as Lord Hoffman himself recognised in the course of his judgment, however effectively one lays down rules or guidance for interpreting interpreting claims, the scope of patent claims is always going to be open to question in difficult cases. Those difficult cases are likely to be where the alleged infringer has thought of a way of obtaining the same effect as a claimed invention using a method or apparatus doesn't quite fit the words used in the claim. And our chairman in activist Eli Lilly pointed out that there are 3 cases in which mechanical equivalents are likely to arise. The third is the one where there is no need to have sympathy for the patentee. I should point out that the Court of Appeal in that case said you shouldn't look at prosecution history. But of course, apart from the fact that I disagree with the Court of Appeal and agree with Richard Arnold, in any event, that doesn't affect the principle. It's frequently clear from the specification itself that a claim has been deliberately limited at some point by the patentee. For example, the claim is narrow in description, or contains an apparently arbitrary but clear limitation on scope. Such matters can, and in my view, should be taken into account. So, is it to be fair protection for the patentee or reasonable certainty for third parties? Or can both be achieved as the protocol requires? I'm afraid it seems to me that difficult cases are always going to give rise to differences of opinion amongst both those skilled in the art and the judiciary. And the outcome of such cases is as likely to turn, whatever the judge says, on whether he or she thinks the patentee is being grasping or the infringer is trying to get away with something. It's a rare borderline case in which a skillful judge is unable to write a persuasive judgment to match his or her predilections either way. So I think that neither fair protection nor reasonable certainty is likely to be achieved in every case. There are always going to be cases which lead to differences of opinion. Cases like Vanderlei and Roman Williamsberger would give rise to just as much dispute now as they did when they were originally decided, which is, as I said at the beginning, where we came in. Thank you.